One of the most important issues that companies face is the disconnect between stock prices and the value of their intellectual property. Very often, frankly, stock prices simply do not adequately account for the intellectual property position of companies. And you have to look at this from both an offensive and defensive point of view. From a defensive point of view, the issue often is, are there competitors who have acquired or may acquire in the near future intellectual property rights that can actually put a company out of business or depress a company's profits or interfere with its ability to market a product or a service? On the offensive side, the issue is, has the company done a sufficient job to obtain, procure, and enforce its own intellectual property rights? Has the company, does the company have a realistic understanding of the value of the patents, trademarks, and other intellectual property rights that it owns? If I was on the board of directors of a major company, or if I was a senior manager, I would be very worried that appropriate due diligence be conducted in connection with financial reporting on the value of intellectual properties. This becomes particularly important today as we see more and more mergers and acquisitions between large companies and kind of smaller biotechnology companies, smaller companies that can contribute to the pipeline of new products for larger companies. And these mergers and acquisitions are often really valued based on factors that do not necessarily include a realistic perception of intellectual property rights. So I'm now advising my clients, from CEOs to board members, that when you're involved in these transactions, it is very important to do your due diligence. Hire intellectual property counsel. It's worth the price. You will find that they can provide due diligence protections for you and information for you that will protect you against potential lawsuits by whistleblowers, stockholders, and others who might otherwise have a basis for accusing you of not doing your homework in connection with these transactions. Well, I'm constantly surprised about the extent to which both investment bankers that are advising large companies and their executives fail to realize the importance of conducting due diligence on IP issues before engaging in these transactions. Very often it becomes an afterthought, or perhaps they view conducting due diligence as a nuisance. But the reality in this day and age, when times are tough, there are a lot of people out there looking for excuses to sue boards of directors, shareholders, senior executives, and there are new, as I've said before, there are new statutes allowing whistleblowers to come in and blow the whistle on executives for failing to conduct due diligence or failing to disclose the truth about intellectual property rights and the value of them. As I said a few minutes ago, you have to look at the situation both defensively and offensively. By defensively, I mean you have to really have an understanding of what your competition is all about. What intellectual property, what rights do they have? What intellectual property rights can they assert against you and to make your life miserable? I think too many companies fail to understand the importance of looking at the competition and understanding the competition. Patent trolls are a topic of great controversy within the intellectual property world. Many companies and senior executives have the perception that they are being burdened unreasonably with lawsuits by people who have no business bringing those suits, people who are not really their competitors, but who are simply in the business of procuring and acquiring patent rights and then holding up big companies for ransom. The key for companies is to understand that not every so-called patent troll is in the business of doing something wrong or illegitimate. It's not like a phony slip and fall case. Many of these patents are real. Now, on the other hand, there is legitimacy to the concern about litigation costs. Litigation costs, including especially cases brought by patent trolls, are a real problem for companies of all sizes. Patent litigations, the average cost from beginning to end is something between $4 to $10 million per case. Obviously, that's a lot of money. And there are cases where companies expend $60 or $100 million to defend themselves. We've had great success with a number of our clients in helping them find mechanisms for truly controlling the structural costs, not just cosmetic approaches to this, such as different ways of billing, but actually addressing how can we cut back the scope of the case? How can we limit discovery? How can we limit the time that we have to deal with the court? How can we limit motion practice? And we have been very effective in helping clients control those types of issues. And that really helps deal with patent trolls, and it helps deal with the whole specter of costs that are out of control. One of the most important decisions has been made by Congress, and that's the decision to fail to adequately fund the Patent Office. The Patent Office is pretty much a self-funding agency, and Congress doesn't even allow it to keep all of the revenues that it raises from people who seek patents. And the problem that we have right now is that the Patent Office is vastly understaffed and underworked. Therefore, when companies apply for patents, it can be 18 months to 2 years before they even obtain their first office action. This has dreadful consequences for the entire economy. Companies need to get their patents issued because they need to rely on having IP rights in order to make decisions about where to invest capital, where to go forward in terms of the market, how to develop customer bases, how to convince investors to come into their company. What can a company do? A company can apply for the patent. A company can be proactive in taking advantage of some of the pilot programs in the Patent Office for speeding up the patent application process. A company can impress upon its patent attorneys the need to simplify their applications so that they're likely to sail through more quickly. I think the thing that will have the most impact on my clients as we move forward will be being effective in controlling the costs of litigation. It is inevitable that clients who are involved in technological enterprises will be participating in patent, trademark, copyright, and other intellectual property litigation. The key is how those litigations are managed. There are ways to effectively manage and conduct those litigations that can make the costs palatable, and the investment in those litigations can actually pay off in terms of developing the company's patent portfolio and developing a reputation that a company is not a patsy, that they're going to actually, they're not going to be held up for ransom on the one hand, and on the other hand, they're going to be aggressive in enforcing their own intellectual property rights. In-house counsel are in a difficult position. Very often, they're just too busy to really provide effective oversight over litigation. But not only that, when general counsel talks to the CEO and the CEO says, you got to cut costs by 10 or 15% in the legal department, there's a little tug and pull there. Do the litigation lawyers in-house really support cutting costs? Do they really believe that's a good thing? And often they really don't. And so one of the things that we've been advising clients to do is bring someone independent to help you evaluate legal costs. Bring someone in who can give you kind of an independent take on what you can do to control costs and where you should spend more money, where you can spend less. One very specific way a company can control litigation costs is to do what we call front loading. A lot of the work that lawyers do in traditional cases is backloaded, and lawyers wait until the end of the case to do some of the really core analyses that are necessary to go to trial. However, if some of that work is front-loaded, some very huge cost savings can be, very big cost savings can be obtained. For example, if at the beginning of the case, a company decides what are the true issues that we're really going to take to trial, what evidence do we really need to prove our case? And if you focus on those issues and on those matters very early on, you can reduce the scope of the litigation from the very beginning. If you can narrow the actual claims, defenses, and issues that are actually being litigated, you obviously reduce the scope of every aspect of the case, from discovery through trial. Well, one of the problems that companies face in analyzing the value of their intellectual property is we have a changing landscape in terms of the legal standards that are applied to analyzing patents. So over the past 3 or 4 years, we've had a series of Supreme Court decisions which have kind of cut back the extent to which patents have value. For example, in the KSR decision, the Supreme Court effectively made it much easier to prove that patents are obvious. In the more recent Bilski decision, the Supreme Court made it more difficult to obtain business method patents and adopted a standard that will make it very difficult in the future to know whether your business method patent is really valid or not. Similarly, just last week, the Federal Circuit issued a new opinion on the issue of inducement of infringement, which is going to be a real hindrance to generic pharmaceutical companies such as Dr. Reddy's and Sun and Teva. The decision seems to indicate that this concept of skinny labeling may no longer work to avoid willful infringement. And nobody really knows what evidence will be sufficient to prove inducement of infringement. The decision just last week is going to create great uncertainty on both the innovator side and the generic side in the pharmaceutical industry. These types of uncertainties make it very difficult to evaluate intellectual property rights, and that's why when companies consider mergers and acquisitions and other transactions, they really need to bring in experienced IP counsel to help guide them through this process. One of the most important issues that will be resolved in the court in the next year or so is the standard for proving inequitable conduct. There's been great uncertainty about that issue, and the Federal Circuit has decided to hear the issue en banc. The briefing is going on as we speak, and I suspect that we're going to have a major decision in this area in the next 6 months or so. Inequitable conduct involves charges that a company acquired patent rights by committing fraud on the patent office. They engaged in conduct that was inappropriate. Either they misrepresented material information, or they failed to disclose material prior art, or engaged in other conduct in prosecuting the application that rises to the level of fooling the patent office into issuing a patent that shouldn't have issued. Depending upon the outcome of that decision, it's either going to be harder to prove inequitable conduct or easier, and it's not clear how the court is going to decide the issue. But inequitable conduct, one way or the other, is destined in the future to be one of the real battlegrounds in intellectual property litigation. You know, companies faced with the issue of what to disclose about their intellectual property rights and intellectual property litigation are often reluctant to say too much. And so the question often is, do I say more or have I said too little? And those issues really can't be addressed without understanding the substance behind both the intellectual property rights at issue and the litigation. And those types of issues are becoming very important. You have a company that has made $60 million in profits last year, and that's under economic pressure, and maybe they're facing even a slower growth in the next 2 years. And then all of a sudden, they're faced with a litigation concerning a piece of intellectual property of a competitor where the damages sought could be, $2 billion. Well, how do you disclose to your stockholders and potential investors what that case means and what the likelihood of success is? Those are major issues, and nobody can really make those decisions until you know the facts and you have at your hands the detailed information concerning that lawsuit, concerning the patents involved or the other intellectual property. And then make a decision as to what is necessary to adequately disclose to shareholders and investors the situation. One of the areas that I think is extraordinarily important is I think we're going to see a lot more copyright litigation, particularly in the field of software. I think people are going to start to recognize that copyrights can be very valuable, and enforcing them can be almost as good as enforcing patents. And I think clients are starting to realize this. And certainly copyrights are easier and cheaper to obtain, so getting copyrights is easier, and the trick is learning how to litigate those cases. And I think a lot of my clients are pushing in that direction.